Not everyone's connected yet. Okay, now it looks like everyone's connected. This is JLLJ Development LLC versus Quad Casinos Gaming Authority, docket number 21-189CB. This is the time set for hearing on the plaintiff's motion for entry of default. I'll take appearances first for the record. Plaintiff first, please.
Andrew Broder and Michael Perry for the plaintiffs, JLLJ and Lansing Future.
Thank you.
Jeffrey Rasmussen for Kuwait Casinos.
Okay, Mr. Broder.
Yes, I'm going to do the argument today, Your Honor. Before I begin, I want to make sure that the court is aware of the Court of Appeals decision that was rendered about 45 minutes ago.
Yes, they sent it directly to me.
All right. I wasn't certain of that, Your Honor, and clearly it's important that the court have that information because you see, Kuwait filed an emergency motion in the Court of Appeals just about a week ago, citing this hearing as the reason for the emergency and imploring the Court of Appeals to stay this proceeding and not have this hearing. And as Kuwait argued to this court unsuccessfully a few weeks ago, Kuwait urged the Court of Appeals to recognize that there was already an automatic stay of proceedings, or alternatively, that the Court of Appeals should grant a stay of proceedings. And of course, the Court of Appeals has declined both of those requests, due in part to Kuwait's dilatory filings. No surprise there, I suppose, Judge, but also because Kuwait, according to the Court of Appeals, did not convince the Court of Appeals that it needed to intervene at this point. So with that green light to proceed here, I want to just briefly address the court as to why a default is appropriate today. In fact, the motion and brief which I filed in support of this request describe in detail the reasons supporting the default request. And I know this court always carefully reviews those pleadings, so I am not going to belabor the matter. But suffice to say, I recognize and my clients recognize that entry of a default is indeed a serious sanction. However, in this case, it is the only one that makes sense at this point. When the court looks, as I'm sure it did, at the case law, which was cited, and I have in front of me in particular the statements of the Court of Appeals in the Mantura case, a case permitting an entry of default for a discovery violation just less than 2 months ago. The Court of Appeals lays out several factors that the trial court should look at in determining whether a default is appropriate. One, whether the violation was willful or accidental. Well, we know here that Kuwait hasn't violated the court's orders accidentally. Every single violation has been willful and deliberate. That includes the discovery orders, the contempt orders, every single order I can think of. I don't know that Kuwait has complied with a single order in this case. That then leads to the second factor, the party's history of refusing to comply with the previous court orders. Well, we can check off that factor too, because Kuwait has simply, from the start of this case, refused to comply with every order of the court, whether it was the order of the court entered initially, finding that sovereign immunity had been waived and that the court's jurisdiction was appropriate. They violated the discovery orders. They violated the contempt orders. Even as of today, Kuwait has not purged its contempt. So the party's history of refusing to comply with previous court orders is fully satisfied here. They haven't complied with anything. The prejudice to the opposing party. Well, clearly my clients have been prejudiced, not only financially, but they're in the position now where we're about ready to proceed to trial. The defendants have not filed, the defendant, I'm sorry, singular, has not filed any witness list, hasn't provided the discovery, hadn't done anything that the court's required. Entry of a default is the only thing that makes sense because my clients haven't been armed with the ammunition that they expected to receive through discovery to help them address the issues as to liability. So, and we've gone on for what, a year now. So over the course of a year, Kuwaitan has done nothing but delay these proceedings, file frivolous motions, frivolous objections, frivolous appeals, and has even gone to the federal district court to try to delay in enjoying this case, and the federal judge declined to do that too. So there is no question that my clients have been prejudiced. The next factor, whether there exists a history of deliberate delay. Well, I've really already spoken to that matter. Those three factors all merge into one. Kuwaitan has simply from the start delayed. The degree of compliance with other parts of the court's orders, I don't know that they've complied with any order of the court. They did send in $1,500 to the clerk of the court, but that's not what the court ordered. They certainly didn't pay the other monies, the fines that were imposed to purge their contempt. They haven't provided the discovery. They haven't provided a witness list, so they haven't complied with anything. Attempts to cure their defect. They haven't done that. In the court's contempt order, the court laid out a roadmap for Kuwaitan to provide the discovery and pay within a certain time frame or else pay certain fines. They did neither. They neither provided the discovery nor did they pay the fines. Whether a lesser sanction would better serve the interests of justice. Frankly, I can't think of a lesser sanction here. We've tried everything. I've been practicing law for over 45 years. What I've seen in this case is positively breathtaking. I mean, Kuwaitan and its attorneys have done everything possible to ignore the court's orders, to insult the court, to accuse me of misconduct by not providing Kuwaitan with the court's July order when I emailed it to him within 45 minutes of the time I received it. I mean, they've done everything conceivable to flout the authority of this court and its orders, and there is nothing else left to do besides enter of default. I have provided the court with a proposed order, and I hope the court enters it today. Thank you.
Thank you. Mr. Rasmussen?
Thank you, Your Honor. One of the things that Mr. Broder leaves out is that his contract has now been declared void ab initio by an entity that has the sole authority to issue that order, which is the Tribes Gaming Commission. It's void ab initio. There is no contract here. And I'm surprised that he leaves that out, because that ultimately, we know where this case is now going, because the contract was declared void ab initio by an entity with jurisdiction over that issue. And so this case is all over but the shouting. And I'm sure he will do a lot of shouting and calling me names, but their contract, in part because of the extreme overreaching in this case, the arguments that they have the authority that they're alleging in the complaint to, for example, to hire and fire tribal employees, casino employees, control the casino's budget, make veto various decisions by the gaming authority, various things like that. Those things that they alleged in their complaint, those are the extreme overreaching that led to the result that the contract was declared void ab initio. So when we talk in our brief, what we discuss, a couple of things. First of all, that we have provided every piece of discovery that we can lawfully provide without committing crimes on the reservation. We've mentioned this repeatedly to this court, and this court has not dealt with that issue, that we cannot, the court can issue an order telling Kuwaitan to take action on the tribe's casino that violates those laws, but we can't do that. And so the first issue, because this is a motion for default based upon alleged discovery violations, the first issue is whether there's the alleged discovery violations, and the court needs to actually deal with that. That's a very complex legal issue. It gets into Indian law doctrines of preemption and Indian law doctrines of infringement. How can one court in one jurisdiction reach onto another jurisdiction and order people in that jurisdiction to do these things? And we have discussed this, that no, what they have to do is take their order to that court. So that was the first issue that we discussed in depth in our brief. And so far, the court has sidestepped that issue. And I'm not sure why, because it is such a fundamental issue, because it is the discovery violation they're alleging is something that we simply deny has even occurred. We have provided every piece of discovery, every piece of information that we can lawfully provide without committing crimes. And we are not going to have our clients committing crimes on the reservation. So that then eliminates the discovery violation, which is the basis for this motion. As we also then discuss, the court to date, and Mr. Broder tried to slip in that this court has decided jurisdiction, and we've gone through this history before. And even the federal court, when they went to the federal court said this court hasn't decided jurisdiction. It said it decided something that was it viewed as leading to the result on jury, but it has decided jurisdiction. A court can go on to these issues, can't issue default until we have a decision on jurisdiction. So we filed our motion to dismiss this matter on summary judgment based upon lack of jurisdiction. That was filed today. That is the proper procedure for determining that threshold issue, rather than going on to issuing a default on a case that the court doesn't have jurisdiction over. And as we discuss in that summary judgment motion that is now pending before this court, we discuss, among other things, the Indian law doctrines of infringement and preemption that haven't been resolved in this case. We discuss the fact that their contract doesn't even exist anymore because of their overreaching. It was void ab initio because of their overreaching. And those are issues the court ultimately has to decide before it can go on to a default. As we also discuss, our view continues to be, despite any orders that have come out to date, because those orders can still be appealed or further review can still be sought, our view remains that this case is currently stayed. And finally, the other issue, and what Mr. Broder wants to skip over, is we have been operating, despite his contentions, we have been operating in good faith to attempt to get decisions on, not only on sovereign immunity, but on those jurisdictional issues, those fundamental jurisdictional issues that really will ultimately control this case. If they don't have a contract, how can the court exercise jurisdiction? Those sorts of things. If they can this court reach onto the tribe's reservation and make orders applicable in that jurisdiction and order the parties to do things in that jurisdiction? Those are issues we've been trying to deal with in good faith, and we've been trying to get resolved. And Mr. Broder wants to cite all of these actions we're doing, try to get these issues resolved, and proceeding in the on legal paths to get those issues resolved, and using that, which is what attorneys do, using that as his basis for saying we're in default. And we've been as active, I think the court will have to say, we have been as active as anybody in that this court has seen in trying to get issues presented and resolved. The fact that the Court of Appeals chose to deny the application for appeal, they did not say that it was frivolous. This court has not said that what we've been doing is frivolous. It has disagreed with us. And this is fundamentally what attorneys do. We have been trying to get the process to get those issues resolved. We have been trying to provide the discovery that we can legally provide while not providing the discovery that we cannot provide. We have been trying to get a decision on whether or not this court has jurisdiction. So we've been trying to do what we need to do. And as Mr. Broder acknowledges, default is an extreme remedy, and it is not to be done in order to punish somebody for doing the legal steps that are permitted in order to try to get, for example, appellate court review, in order to get federal court review of the line between state court jurisdiction and federal court jurisdiction. The fact that we have been doing those is actually the reason that this is not default, not the reason for it to be default. We have been trying to do what we can do. Finally, the other one point that I wanted to make is that ultimately, when we get to the end of this case, since they don't have a contract, there's no potential for remedial remedies, and that this court, what it should do is set the motion for a decision on summary judgment on subject matter jurisdiction, which this court has acknowledged it hasn't decided, to set that for a hearing, get that issue decided, and then if we aren't able to prevail on that issue, which I think we will be able to prevail on that issue since there's not even a contract in this case anymore, that the contract was void ab initio. But once that issue is decided, then we can go on to, well, what would be the appropriate method of proceeding if the court were to deny that motion. If the court were to finally say whether or not it has jurisdiction over this case, we would hope it would say it doesn't. But if it said it does have jurisdiction over this case, then to talk about whether we have to comply with that order, rather than saying we have to comply even though the court hasn't yet decided that issue. And what we have been trying to do is get that issue decided. So we've been operating as best we can within that limitation, and within the limitation that we can't ask our clients to do things on the reservation that are criminal in that jurisdiction. So what we would ask is that the court set the motion for a summary judgment for a hearing, that when the court then rules on that, then to give the parties time to process that, to give us some time to process the surprising issue that order we got out of the Court of Appeals today, and to take appropriate actions to remedy that. But we aren't in default. We are as active as we can be in this case. We have provided the discovery we can provide.
Mr. Broder?
Your Honor, I would just like to respond to a couple of points, because I imagine the court might be wondering what on earth Mr. Rasmussen is talking about when he refers to the fact that the development agreements have been determined to be void ab initio. Here's what he's talking about. Well, let's go back to the beginning. As the court knows, the development agreements were at the heart of the defendant's motion originally to dismiss the case, and our response, and both sides relied on different portions of those development agreements, and the court ultimately had its own view of the provisions in the development agreements and determined that sovereign immunity had been waived. So now at the 11th hour, apparently because Kuwaitan has not been particularly happy with this court's rulings or the Court of Appeals rulings, it, I gather, filed some sort of petition in what's called the Sault Ste. Marie tribe of Chippewa Indians in the Gaming Commission. Now, the court knows, if you simply look at the caption, that the defendant here is an instrumentality of the Sault Ste. Marie tribe of Chippewa Indians. The members of the board of Kuwaitan are the same members of the board of the gaming.
We're going to object to that. That's not true, and he has no basis for saying that.
Your Honor, I'd like to finish, please.
Do not interrupt. Go ahead, Mr.
And they're the same members of the commission. So attached as an exhibit to Mr. Rasmussen's motion for summary disposition, which he filed 2 hours ago, is an order of their own self-serving gaming commission, where they're all the same people. And they say that a hearing was held on April 5, 2022, on the petition of the tribe seeking a declaration that the turnkey agreements and amendments were void ab initio. The hearing was properly set by written notice to the commission. A quorum of the commission was present. Well, we never knew about any hearing before this commission. So what Mr. Rasmussen is suggesting now is that somehow he can go off on some half-cocked pursuit within the tribal structure and get its own self-serving declaration without any notice to us that the contracts that have been litigated in this court and have been interpreted by Your Honor are somehow void. That is not only one of the most ridiculous propositions I have ever heard, but it is also flatly in violation of the provision in the development agreements that says that the borrower, that would be Kuwaitan, hereby expressly and irrevocably waives any application of the exhaustion of tribal remedies or the abstention doctrine or any other law, rule, regulation, or interpretation that might be required as a matter of law in comity with respect to going to the tribal court or any forum of the tribal court. So they waive that, but now they decide they can go there themselves and get a self-serving order with which we had no notice at all and say to this court that, well, the underlying development agreements have now been determined to be void by the commission, so there's no basis for this lawsuit to go forward. That is beyond bizarre. It is almost unimaginable that any attorney would proceed in that manner and make that sort of representation to this court. This court has for a year dealt with the development agreements and the orders that have naturally flowed from Kuwaitan's conduct, and it can't do an end run around this court by going to their own captive commission to have that commission say something that's inconsistent with what this court has ruled. That in and of itself is indicative of the kind of shenanigans that the defendant has pulled from the start of this case. And if a default isn't warranted in this case, I don't think I'll ever know a case where one is warranted. I've said enough, Your Honor.
The plaintiff seeks entry of a default in accordance with MCR 2.313B2 for the defendant's failure to obey an order or to provide or permit discovery. The defendant has in fact refused to comply with this court's orders. The defendant has not answered discovery as was ordered on October 27, 2021, and the defendant has failed to provide a witness list ordered in the October 18, 2021 scheduling order. The plaintiff outlines other ways in which the defendant and defendant's counsel have ignored and defied the rules, procedures, and orders of this court. And I will say that I don't hold pursuing any legal avenues of relief against anyone. But here we indeed have frivolous filings, repeated failures to appear, and outright refusal to follow court orders. I learned even today that even the court's ruling that there is no stay in this case is being just disregarded by the defendant or not acknowledged or followed. Many, if not all, of the actions that have occurred in this case are justified by the defendant on exactly the same grounds, that the defendant has sovereign immunity or that this court lacks subject matter jurisdiction or some variation of either. I ruled on the sovereign immunity issue on June 23rd, 2021 from the bench, and then on July 21, 2021 by written order. And the defendant was well within its rights to appeal that with an application for leave with the Court of Appeals. The defendant didn't do that. The defendant filed an appeal by right, which the Court of Appeals has rejected, and now a delayed application for leave to appeal that the Court of Appeals has also rejected. The defendant has also repeatedly claimed that this court neglected or refused to rule on subject matter jurisdiction, and somehow it was asserted quite some time ago now that somehow prevented the defendant from going to the Court of Appeals immediately. But none of that is true. The Court of Appeals does de novo review on motions for summary disposition. So if someone feels that they properly raised an issue and the trial court didn't rule on it, you've preserved it, the Court of Appeals will do de novo review and they'll look at it regardless of whether a trial court ruled on it or not. But I did address subject matter jurisdiction. And no matter how many times I explain this, I know the defendant will never accept it. I don't know that it matters, but the federal court said exactly that. Quoting from the federal court's order, Kuwaitan makes much about the fact that the state court did not decide the issue of subject matter jurisdiction. This argument is unavailing because Kuwaitan does not raise any other arguments in its moving brief regarding the state court's subject matter jurisdiction, except the issue of sovereign immunity, which the state court ruled on. In other words, Kuwaitan has not supplied an argument for why the state court lacks jurisdiction. Even in its, and that ends the quote, even in its response to this motion, the defendant's claim of privilege with respect to the discovery isn't even thinly disguised. It's a claim of sovereign immunity and the jurisdiction of this court. And it's the same old assertion that nothing can proceed until this court rules on subject matter jurisdiction. Well, how can I order the tribe to provide discovery? The defendant asked today. Well, because the defendant, Kuwaitan Casinos Gaming Authority, has waived sovereign immunity and agreed, as I've ruled back last summer, per the language of the contracts in this case, has agreed to submit to the jurisdiction of this court. Now, I would have welcomed a resolution of those issues from the Court of Appeals, no matter what that resolution was, but the defendant did not do that in a timely or correct manner, and now that avenue is foreclosed for now. But that resolution could have been had a long time ago with a timely delayed application for leave to appeal following the ruling on the motion for summary disposition. It's now April 13th, 2022, and we are hardly, if at all, any further along than when we were on July 21, 2021. I've tried to get the defendant to comply with discovery, even going so far as contempt with regard to to discovery a chance to purge the contempt completely just by providing the discovery. The possible sanctions under MCR 2.313B2 have been considered, and some of them have already been employed, but to no avail. And I'm satisfied that there's no way to get the defendant to participate in this case, no matter what this court does, because the defendant will always argue sovereign immunity and subject matter jurisdiction. This is a willful course of action. There is a history to it, and it has prejudiced the plaintiff from proceeding. This has all deliberately delayed this case. Other measures have failed, and the defendant has shown no desire to cure any defects or provide discovery, but instead shows open, repeated defiance of this court's orders, even today. So for those reasons, I am signing the order granting the plaintiff's motion for entry of the defendant's default. And specifically, this is an entry of default as to liability. The defendant is still entitled to participate at trial on the issue of damages. So they will be able to cross-examine witnesses called by the plaintiff, of course, but they will not be permitted to call witnesses themselves, having failed to even submit to the simple order of this court to provide a witness list, file a witness list. The plaintiffs are entitled to an award of attorney fees and costs with respect to preparation of this motion and attendance at the hearing. I've previously gone through the factors and ruled on an hourly rate, and I actually don't have that right in front of me, but I believe I found $350, but correct me if I'm wrong, and Mr. Broder, please inform me of the number of hours.
Your Honor, I would only be guessing right now. I don't want to do that. That's not fair to anyone. I believe that the hourly rate for me was about $380 or $390, and for Mr. Perry a little less. But and I just don't want to guess as to the hours, but I could certainly provide that to the court in a supplemental filing.
Okay, then I think what I'll do is I'll just take your paragraph 5 of your order and say plaintiffs are entitled to an award of attorney fees and costs in an amount to be determined. And I have crossed off the rest of the sentence, and I've signed the order and dated it today, and we will have it entered and copies.
So may I then submit a supplement to simply advising the court of my time, and we'll certainly look up the hourly rate that the court previously set.
All right, thank you. That will conclude this hearing.
Your Honor, may I ask a question?
Yes.
We received a reminder the other day of the pretrial conference for Tuesday, April 20. And then this morning we received, or early afternoon, defendant's summary disposition motion on subject matter jurisdiction. And we were curious as to how the court wanted to handle the pretrial conference in light of the newly filed motion for summary disposition, now also in light of the court's entry of the default. So we're seeking a little guidance on how we should proceed next Tuesday.
Well, if we're up to a pretrial, then I don't have the scheduling order right in front of me, but I'm going to guess that the time for filing dispositive motions the deadline has passed, correct?
That might be Monday.
It might be Monday. Oh, okay.
It might be Monday.
Your Honor, I was muted and I by the court, as I understand it, but we wanted to object to some of Mr. Broder's statements of fact that were false, and we weren't able to because we were muted by the court when we made our first objection to one of those. So we haven't been able to create the record that we feel like we wanted to create regarding his, yet again, just misstatements of fact. As far as our motion for summary judgment, it is a timely motion, and our view is that it does have to be considered. It does go to subject matter jurisdiction, and it raises issues, particularly the issues regarding the federal law doctrines of preemption and infringement, which are not sovereign immunity issues, just as the objections that we made to discovery are not sovereign immunity objections. They are objections based upon other doctrines. And so that's what our motion for summary judgment
Chance to
raises.
argue that at the hearing. Right now, I'll take the April 20 pretrial off the schedule, because as long as the summary disposition motion is timely under the deadline, which it appears that it is, then obviously we can't get a hearing in on that. And I think it just would only make sense to take the pretrial off the schedule.
Okay.
So that's
Thank you.
what we'll do.
Thank you, Your Honor.
Thank you. That will conclude this hearing. Here we go.